But for the most part, you know, the kind of domains that we think about and deal with, every domain has a potential legitimate use. You know, it's how you use a domain that, you know, potentially can get you into trouble. You know, obviously we have the trademark infringement concerns, but let me stand back, you can see a little better. But there's also dilution issues when you're dealing with famous trademarks. You got publicity rights when you're incorporating names of individuals into a domain name. But then you also have unfair competition and some other common law, laws out there that aren't really codified on the books and easy to identify, but are always out there as a remedy for a company that thinks that they're being harassed somehow. And in the U.S. specifically, we got the Anti-Cybersquatting Protection Act, which is it's basically UDRP the UDRP on steroids for a lot of practical purposes. The big difference being there that the penalties can be severe. You know, the statutory damages alone can be up to $100,000 per domain. So that's it was enacted with domain names specifically at mind. But to tackle trademarks first, we got to understand what trademarks are designed to do and what they're not designed to do. They're not a monopoly on a word. Despite what a company might tell you in a letter or however they might try to position themselves, they do not have a monopoly on the word. Nike does not have a monopoly on the word Nike. Apple does not have a monopoly on the word Apple. You know, it's how those trademarks are used that limits the scope of protection. One key thing with trademarks is that trademarks need to be distinctive and capable of identifying the company, the source of goods. You know, unlike other IP rights like copyrights or patents, trademark law was not designed to protect the holder, the owner. It was designed to protect the consumer. And that's the big difference that, you know, when people talk about IP rights and lump trademarks in with copyrights and patents, that is a very important distinction there. You know, it is not designed to protect the company. It is designed to protect consumers. And part of the reason that limitations are built into it around this idea of protecting consumers is that you can't have a trademark that is inherently generic or descriptive of the products that you sell. If you sell bicycles, you can't have a trademark on the term bicycles, or else how can anybody compete with you? How can anybody sell competing products if they can't even describe the products they sell? You know, unfortunately, once you get into these lines of suggestive kind of trademarks, there are things that sound descriptive, you know, but for whatever reason, the trademark boards or a court might say that it's just suggestive enough that it's not really descriptive. You know, a good, you know, if you think of consumer goods like, clothing detergents or, you know, things like that that have names that kind of invoke the qualities of it. Trying to think of a good one. You know, like Spring Fresh or something like that for dryer sheets. You know, they smell like a scent of Spring Fresh, so that they are somewhat descriptive, but they're not so descriptive that they're denied protection. But if you look at this kind of spectrum of protection, you can see that when you get towards the generic and descriptive side, there is no trademark rights. You know, you have to invest so heavily into the trademark that it actually gets what's called secondary meaning in the minds of consumers, that they actually don't identify it as a descriptive word anymore, they identify it as your company. Toys R Us is one example, the big toy chain here in the US. You know, Toys R Us, that's about as descriptive a name as you can possibly have. You know, so for the good, you know, majority of that trademark's existence, it really didn't have any protection rights. It wasn't until it became sufficiently famous and distinctive in the minds of the consumers that it had this secondary meaning that it was finally granted trademark protection. So say for like the first 10, 15 years of that company's existence, competitors could have came out and opened a store called Toys R Us right next door, and that would not have been trademark infringement because they sell toys. So how can they not say that Toys R Us? You know, the strongest trademarks then are going to be the arbitrary or fanciful ones. You know, sometimes it can be a dictionary word, but that has nothing to do with the company, what the company sells. You know, Apple computers being a great example of that. I mean, the fruit has nothing to do with what they do. You know, and so it's a very powerful trademark in relation to computer and consumer goods. If they were ever to go into selling fruit, that trademark wouldn't be so strong. And they're branching out in so many different directions these days. Who knows what they might do next? When we think about it from an international perspective, you have to take into account that there's different trademark regimes around the world. And granting of protection in the US and Canada and the UK for the large part is based on first to use. So the first company to use a trademark has senior priority rights to use that trademark. Whereas in the EU and most civil law countries, it's just the opposite. It's first to file. You could have been using it for 10 years, but if you never registered it, somebody else could come in, register it, and be the senior user. One thing that's universal in trademark law, and this has been codified in different international treaties, one of the bigger ones being the WTO TRIPS agreement that basically outlines most intellectual property laws under the WTO regime, and they create some standards of trademark use. One of the big standards is scope of protection and limitations based on the related goods and services. There's this thing called the NICE classifications, and it's this big long list of goods and services, and they have little codes next to them. So whenever you file a trademark registration, whether in a national trademark registry, so let's say the U.S. Patent and Trademark Office, or if you were to use the Madrid Protocol, which is a single application that applies to as many countries as you choose, as long as they are part of the Madrid Convention. They all use these NICE classifications. So it's one area of trademark law that has been somewhat harmonized around the world, and that most trademark regimes use these same classifications. So when you have a trademark, that trademark is limited to the goods and services that it's registered for. So if we use the Apple example again, that Apple trademark is only in relation to the goods and services of computers and consumer goods in which they've registered in their, or at least that they sell. And since in common law countries, US, UK, Canada, since the rights come with first to use, it's basically whatever goods you use it on is where your protection goes. But you also have a lot of fair use protections built into trademark law that try to protect consumers in the public domain from overreaching trademark owners, basically preventing the monopoly theory of word. And one of the big distinctions with these fair use defenses is the commercial applicability. Commercial use of a trademark is much less likely to be seen as a fair use than a non-commercial use. If it's a commentary, if it's a parody, if it's just using the word for its descriptive purposes, those are all fair uses. But if it's a commercial use that overlaps with the trademark and the related goods and services, there's not going to be much wiggle room for a fair use defense there. Once you get into famous trademarks, everything kind of escalates a bit. And this is another thing that is harmonizing around the world. This concept of famous trademarks versus just run-of-the-mill trademarks. Once a trademark becomes famous, you enter into the world of dilution remedies and tarnishment remedies. And that basically is saying that even if the use of the competing use of the trademark has nothing to do with the goods and services that the senior holder uses it for, it's so famous that anybody using it for any purpose is going to dilute the ability of that trademark to identify the company, the senior holding company. So if we use Apple again, Apple is such a famous, powerful brand that if somebody was to come up with, say, Apple running shoes, their lawyers would run to court and say, no. By using this trademark, even on shoes, it's going to confuse customers and it's going to dilute the ability of our trademark to identify us.
What about what happened with the Apple Core, the original Beatles?
That actually ended up,
the
big fight between the two of them actually ended up being more of a contract fight, because way back in the day, in the early 80s, they had already gone to court and kind of sorted these things out. So a big part of their fight was, is this use covered by our contract or not?